everybody, I'm Jesse Weber, and welcome back to Law and Crime, where we cover some of the most interesting live trials in the country today. And I'm so happy you're joining us because we are covering two of the biggest cases in the country right now. And I want to start off with our main trial of the day that we believe will begin at around 10 a.m. So before we get into that, let me talk a little bit more about it. It is the William Riley Gaul case out of Knoxville, Tennessee. As you know, it started yesterday. It's about this former Maryville College football player who allegedly stalked and killed his 16-year-old ex-girlfriend named Emma Walker. And she was a high school cheerleader when this incident happened back in November of 2016. It's alleged that Gaul fired 2 shots through Walker's bedroom wall while she slept, ultimately killing her. We have a short report about this case. Now remember, I want everybody to remember this. He faced 7 charges in this indictment, including first-degree murder, stalking, theft of property, hiding a gun, reckless endangerment, which he just, and I want to make this clear, the reckless endangerment charge he pled guilty to before the trial started, which means he faces, at a minimum right now, anywhere from 3 to 15 years in prison. He also faces charges of employing a firearm during a dangerous felony and killing during aggravated child abuse, which is very similar to the felony murder rule, which we talked about in the Tex MacGyver case. We'll talk about it a little bit more. We'll explain everything that this man is facing. We have a short report about this case. Take a look at this.
The trial of the man accused in the shooting death of a Knoxville, Tennessee teen is set to begin this week. William Riley Gaul, a former Maryville College football player, allegedly stalked and killed 16-year-old Emma Walker, a high school cheerleader, in November 2016. Investigators say Gaul and Walker were involved in an ongoing turbulent relationship and allege Gaul fired 2 shots through Walker's bedroom wall while she slept, killing the teen. Gaul was arrested in connection with the killing after he tried to recruit a friend to help him discard of the murder weapon, but that friend went to authorities, according to police. Gaul is charged with 7 counts, including first-degree murder and felony murder.
Hey, ladies and gentlemen, that is one case that we're covering. We're waiting for a live feed in that around 10 a.m. Eastern Standard Time. But the case we'll start with today, our very first live trial of the day, is the Sean Great case out of Ohio. As you know, we've been following this one very carefully. This is about that accused serial killer who faces numerous charges, including charges related to the deaths of 2 women, Elizabeth Griffith and Stacey Stanley Hicks, as well as the abduction and rape of a 3rd woman who has been identified as Jane Doe. So this man, Sean Great, faces everything from kidnapping charges to rape charges to murder charges. It's not easy to listen to. It's not easy to see, especially since yesterday what we saw was some of the autopsy photos. We also tried to understand how this evidence was collected. Remember, these 2 bodies and this woman who was allegedly kidnapped and raped were found in this house of horrors. There were decomposed bodies, there were maggots, there were ties that were tying women up. It was really a really disturbing situation, and the jury saw a lot of those photos. And I have to let you know, ladies and gentlemen, that the next question becomes, will the jury actually see a rape video? That's right. It is alleged that the rape of Jane Doe was captured on a cell phone footage, and the question is whether that will be played to the jury. We'll talk about that a little bit more. But again, we have a short report about this case as well. Take a look.
The surviving victim, who escaped from a suspected serial killer by calling the police while he slept, took the stand. The unidentified victim described how she first met with the defendant, Sean Great, who is accused of kidnapping and sexually assaulting her and is charged in connection with the murders of 2 other women.
What's the problem? I've been abducted. Who abducted you? Sean Great. Where's she at now? Asleep.
She claimed Great was like an older brother to her before he snapped.
So when he started pulling the Bible from my hands, I just looked up like curious, like, what are you doing? And that's when he says, you're not going anywhere. I tried to push him away and get up. I was just doing everything. Trying to kick, punch, but everything I did, he just did it so much harder. I think when I stopped struggling and fighting, He asked me if I had enough, and I think I just remained motionless, and so he released his hands. He started pulling off my clothes.
The victim described the assault she endured at the hands of the defendant.
At some point on the night of the 11th, were you sexually assaulted?
Several times.
How were you assaulted?
In every way imaginable.
Great faces 23 counts, including aggravated murder and kidnapping. If convicted, he could face the death penalty. For Law and Crime, I'm Rachel Stockman.
Okay, so we have a lot at stake here in both of these cases, the Great case and the Riley Gaul case. We want to talk about both before we go live into our courtrooms today. And joining me on set is my good friend and attorney, Misty Marris. Misty, good to see you.
Thanks, Jesse. Appreciate it.
Well, let's start with the Great case. Sad to listen to these facts, but from a legal perspective, the defense is not doing much. They're cross-examining some witnesses, trying to put a few questions there. They reserved the right to not have an opening statement. What are they planning on doing here?
Yeah, well, what I think in a case like this, where there are so many facts that are detrimental to the defense, this is a really tough case to defend. I think we can all agree on that. So what the defense wants to do, sit back, listen to the evidence, unfold, not give their theory of the case right from the get-go, because they want to see what comes out, what testimony, what evidence, what can they actually poke holes in. So it's a strategic choice. Well, oftentimes risky, though, Jesse, because the jury likes to know where you're going in a case.
I agree with you, and I don't see it yet because the prosecution so far has established him on tape admitting to the crimes. They had a tape yesterday that they showed of him putting one of the chokehold, showing how he actually choked out one of the women. It is alleged that there is a cell phone video of him raping one of these women. Let me ask you about that. Do you think that will be brought into evidence? Do you think that jury needs to see that?
The defense is going to have to vehemently argue to keep it out. So it's the standard is, will this be so inflammatory that it will be prejudicial to the defendant?
But if you have actual evidence of a rape, isn't that you have to put that?
Well, it just depends on the nature of the circumstances. The court could say, well, he's already admitted to this, or there's enough evidence otherwise that there's sufficient evidence on the record that a jury can come to that conclusion. But Jesse, you're right. As a prosecutor, you're going to say, this is on tape. Why is it on tape? Because of this guy. Yeah. So at that point, you may see it come in. I do think from a defense perspective, you obviously want to keep that out, because if you have something else you can argue from a defense side, there's enough here that a jury can draw the conclusion that this rape occurred. Seeing it, physically seeing it happen, is a lot different, because that's going to put the jury in a place where this is an unforgivable act, and may not be clear-headed approaching all of the different crimes that he's accused of, because
and let's not forget,
there's a lot here.
This same jury will determine what ultimately happens to him, and it's not just guilt or innocence. It becomes those other sexual violent predator specifications. Does he deserve the death penalty? So you don't, in other words, what you're saying is, let them determine guilt or innocence based upon this, but do not put so much extra evidence that they don't really need to see these gruesome details, because they're just going to not make a proper decision about what should happen.
Right. What we saw yesterday, the medical examiner testimony, some of that forensic stuff, that's already pretty brutal.
We saw the bodies.
Seeing the bodies. Yeah. All of that is very brutal to see. But that's really where the argument comes. What will be so inflammatory that the defendant doesn't get a fair trial? And from a prosecutorial or even the judge's perspective, you want to watch it, because you don't want some appealable issue there that might put the verdict at risk. But in a case like this, for the defense attorneys, you have a bad case. You don't choose the facts. You're dealt the hand that you have as a defense attorney. You're trying to save your client's life. That's what's going on here. So the defense attorney's watching the case unfold, and they're going to try and save their client from the death penalty. There's too much here. There's admissions. There's the chokehold. There's the video. There's this house of horrors, as you described it. And you have a living victim.
Yeah.
Oftentimes, you don't have a living victim.
No.
So in this case, I think there's 0% chance there's not a conviction. The question is the death penalty going to be what happens here?
That ultimately becomes the question. Okay, everybody, so that's the Sean Great case out of Ohio. We are going to cover that. I'm waiting for a live feed in the courtroom. We'll talk about that in a minute. But, Misty, I want to switch gears real quick. I want to now talk about our main trial of the day, the William Riley Gaul case. Now, this is an interesting one. it seems the prosecution laid out a pretty strong case against this guy. If you go on lawandcrime.com, we have some great articles talking about the opening statements. But is the defense saying, all right, our client just pled guilty to firing a weapon into the house, at the house, but he never intended to kill this girl? What am I not getting?
Yeah.
How does that make sense?
Well,
I wanted to fire a weapon, but I didn't want to hurt anybody?
Right. The prosecution laid out a really great case with some facts that a juror is going to look at and say, man, this was a pattern. This was just leading up to a premeditated murder. And that's what the prosecution's showing. From the defense perspective, though, you saw their theory of the case is he did not mean to kill her. He actually meant to scare her. He shot at the house. Obviously reckless. That's why he pled guilty to that other charge, recklessly firing into a dwelling. But he's copping up to that. But there was never an intent to kill. He said they had the defense attorney, a tumultuous relationship, and that in this tumultuous relationship, Gaul did some bizarre things, namely trying to scare his girlfriend so he could come to her rescue. There had been several other instances that the defense pointed to in their opening statement where Gaul had taken some sort of action to scare her and then be her savior. And they're saying this is just another one of those instances gone awry. So there was, and you know, although the prosecution's case seems very strong right now, I'm interested to see how this case unfolds, because from the defense perspective, the one fact that you really have on your side here is that he shot from the outside of the house in.
And the one bullet hit her. So unless this guy is a master assassin.
Exactly. Is he a sharpshooter? Is he a former FBI agent? He's somebody who has that level of training with guns.
Yeah.
I will say the one factor that I thought to be the most detrimental to that theory of the case is some of the stuff that he was arrested with. And I'm just reading this. It's that duct tape, garbage bags, gloves. I mean, that screams body disposal to me.
If you just
so
talk
that's
about,
a problem.
I mean, he was allegedly walking around in this all-black outfit. Afterwards, he tried to dispose of the evidence. It doesn't look good for him.
No, but you look at it, and the defense is trying to double down on that, though.
Right.
They're going to admit that happened. That he was dressed as the man in black.
But he's an 18-year-old kid who was in love.
And he did this before.
I get
trying
what it
to
is.
scare. So interesting.
So let's do this right now. As we wait for the live feed in the great case, I want to play some of the prosecution's opening statement in the William Riley Gaul case, and we can understand a little bit about this case, understand the arguments, and then Misty and I can dissect it a little bit more. Take a look from yesterday. These are the opening statement from the prosecution. Welcome back, everybody. That was the prosecution's opening statement in the William Riley Gaul case. But we're going to switch gears right now. We're going into the Sean Great case out of Ohio. We have a live feed. This is the trial of that accused serial killer. He faces so many different charges, including kidnapping, rape, burglary, and we have a live feed in the court. We're going to show it. As soon as the trial starts, we'll make sure to go to it. I'm here again with Misty Marris. One of the interesting things, Misty, that we learned yesterday, it was hard to do a rape analysis of those two decomposed bodies. Again, we're talking about Elizabeth Griffith and Stacey Hicks, because they were so decomposed, and you listen to that. I mean, how horrific can that be, that these bodies were just left in the house?
Yeah, it's absolutely horrific details here. And again, those are the types of facts that you're going to have, which is hard to say, but the defense attorneys are going to look at that and say, hey, is there something that we can talk about with respect to the expert testimony or the forensics? But the fact that you walked into this house, there's decomposing bodies, there's, ties on the bed. This is not doing the defendant any favors on his quest to save himself from the death penalty.
His quest. Well, let's listen more about that quest. We have a live feed into the Sean Great case. Let's listen in.
The exhibits and testimony that they would be technically converted to something other than a relevant piece of evidence in this matter by way of this plea. So given that sort of stipulation, that is the proposed plea then as to those counts. In essence, we'd end up having to go through a lot of this redacted, create two records. And so that's the stipulation.
Well, counsel will approach.
Okay, ladies and gentlemen, we're not 100% sure, but it sounds like there's a discussion about Mr. Great taking a plea deal with respect to some of these counts. And Misty, you couldn't have said it better. You said you wanted the defense was probably listening to what the evidence was against their client, and they're listening to it. Sounds pretty heavy. What does this mean?
Well, I think what you're seeing is the defense is looking at some of the charges and saying, look, we're not going to be able to overcome the mountain of evidence that the prosecution has presented against our client. So maybe what we should do is talk to the prosecution about entering a plea deal for some of those charges that are really just a no-brainer. This, maybe the rape, avoiding that video being played, might avoid some of the issues that would be ultra-inflammatory to the jury and ultimately lead down the road to the death penalty.
Why wasn't this negotiated before trial?
Well, there might be issues, and this happens a lot, that before trial, in a case like this, where the evidence is so overwhelming that the prosecutors say, look, we're not willing to take the death penalty off the table now.
Yeah.
But now that the trial's unfolding, the defense maybe backs off a little bit on whatever lesser sentence they were looking for and says, hey, look, we're willing to talk about, who knows, maybe life in prison. There's an overwhelming amount of evidence here. And again, the goal in a case like this is generally to save your client's life. So the other thing is, you've got the defendant sitting at that table. He might be willing to talk about some sort of plea that he was not willing to talk about before the trial because he's scared.
What do you think the charges he might plea up to? Would it be, I mean, he faces, burglary charges, rape charges, everything from murder to how he handled corpses. I mean, these are really disturbing charges. What would he remain? What would he just plead guilty to everything, or what would he at least try to fight?
I think he would probably try and fight anything with respect to the forensic evidence that we heard about yesterday that holes could be poked in some of that evidence because of those chain of custody issues, because there are issues with the actual expert analysis of some of those bodies. But with respect to the rape that you have on tape, I mean, that's a no-brainer. I mean, take that and go. Or some of the, maybe even, look, Jesse, he might plead guilty to the murder. He might say, you might cop to it, but with the caveat that death penalty is off the table. And that's really what, it happens a lot in these cases. We've seen it before, that somebody agrees to a life sentence and says, look, I just don't have the fight. The evidence is too overwhelming.
So just so our viewers understand, basically what could happen is, all right, the jury has seen so much so far to indicate that he is the guilty party. However, they haven't seen this extra evidence that might be too prejudicial, too inflammatory, that would enrage their senses and say, we want to kill him, we want to sentence him to death. So in other words, there's enough right here to convict him, but let's not show so much that the jury would get, there would be an upheaval.
Yeah, absolutely. And that's what the defense wants to avoid, because once you play that video, and look, we haven't seen it, but I can only imagine how absolutely traumatizing and horrific it would be to even watch it. So think about what that means when the jury thinks about what it was like for that actual victim and says, look, I don't care what the evidence is. This guy should die. This guy should face the death, should get the death penalty. But this all, when you're talking about a plea deal, this all depends on what the prosecution is even willing to do. I would doubt that in a case of an accused serial killer where there's this level of evidence, the prosecution would agree to anything less than a life sentence without parole.
We're talking about his lawyers. We're talking about this. That's the man himself. That's Sean Great. This is a guy who's on tape admitting to crimes. This is a guy who was on tape showing how he put one of the victims in a sleeper hold. This is a guy who allegedly kept the bodies in the house. He was found in that house with the decomposed bodies and this woman running outside. So what's going on in his mind? What does he ultimately want out of this? We asked the question about serial killers and trying to understand this. Why would he keep the bodies in the house? Allegedly keep the bodies in the house. Why is this a sense of pride? What is he hoping to get from this trial? What is he hoping that will ultimately happen to him?
Well, you see, oftentimes in the cases of serial killers, and if you can talk to a criminal psychologist about this or a forensic psychologist, and they'll tell you that there is some sort of psychological almost necessity of keeping trophies from the crimes. That's actually not very uncommon in the cases of serial killers. So that could be why he keeps these bodies in the house. That could be why, they found him in this house filled with evidence as opposed to somebody who's really trying to get away with it and might dispose of all that because of this compulsion to keep something that reminds them of the crime. But I would think the fact that the defense is approaching a plea deal right now and they're talking about this in the courtroom, which is what we believe is happening, it is a lot different for your lawyer as the defendant sitting in that chair to explain this is what's going to happen at trial and this is what you could potentially face, as opposed to seeing it unfold. So maybe we're seeing a very human aspect of somebody who committed some very inhuman acts that he's afraid for his life and now is directing his attorney to try and see if they can find some sort of plea deal.
I don't know. I think at one point it was alleged that Mr. Great wanted to die, or at least knew what his fate was going to be. Okay, so the attorneys are walking back. Those are Sean Great's attorneys. Hard reading body language. They look a little defeated, but we're going to have to see what happens. As soon as we have the audio, we're going to jump back into the courtroom, so I don't want to miss anything. And we do have the audio, so let's listen back in now. Wow. Wow, ladies and gentlemen, did you hear that? Mr. Great just pled guilty to 15 counts in that 23-count indictment. I want to talk about this right now with Misty Marris. Okay, Misty, let's analyze exactly what he pled guilty to. He pled guilty to gross abuse of a corpse in connection with Elizabeth Griffith. He pled guilty to burglary, tampering with evidence, the rape of Stacey Hicks, gross abuse of a corpse for Stacey Hicks, the unauthorized use of a vehicle, the kidnapping and multiple rapes of Jane Doe, robbery, three additional counts of burglary, as well as breaking and entering. What this ultimately means, though, is what's still on the table is aggravated murder of Elizabeth Griffith. That's 2 counts. Kidnapping of Elizabeth Griffith. The aggravated murder of Stacey Hicks. That's 2 additional counts. As well as 2 counts of kidnapping of Stacey Hicks and the aggravated robbery of Stacey Hicks. In other words, Misty, if we can understand this correctly, he is saying he had nothing to do with the murder of these 2 women, even the abduction of these 2 women, and he didn't harm these 2 women. But he did manipulate their corpses. He did rape this 3rd individual. He did rape Stacey Hicks. I mean, what are you making of what we just learned today? Because we're shocked.
Yeah, look, I mean, sounds a little fishy, Jesse. Sure, I did all these other things, but I had nothing to do with these kidnappings and murders. But I think what we see is you and I predicted it perfectly. This is where the defense is going. So the charges that are left, what he did not plead guilty to, are the ones that would have a penalty of the death penalty. So instead, he pleads guilty to the other charges, many of them dead to rights. All of a sudden, the issue of the rape is no longer a question of fact for the jury to decide. He has pled guilty. So now what? That video, that inflammatory video that would have been horrific to watch.
You're talking about the video where he was raping Jane Doe.
Exactly, and that video, which was going to be something that may or may not come into evidence, is now irrelevant because there's no question he's pled guilty. The defense has gotten rid of that as an issue. Now they're going to probably sit there silently through the remainder of the prosecution's case and hope they can convince a judge during the penalty phase, because I think where I see this going, guilty on the other charges that are still left, and then the defense tries to convince the judge, the jury, not to impose the death penalty. That is where this case is going.
So right now, based upon what he pled guilty to, he faces anywhere from 72 years to life in prison for those charges. But he's okay, in other words, with being life in prison, but just don't sentence me to death for the other thing.
Exactly what it seems like, because the judge made it very clear. 72 to life, but a minimum of 50 years. This guy's in his 40s. That means he's going to be in his 90s before he even has a shot at getting out. It's essentially a life sentence. He's obviously okay with that.
But by pleading guilty to all of this, you know, if you're sitting on the jury, this guy just pled guilty to 15 counts in this 23-count indictment. You said they're most likely going to convict him of the murders. But how are they not going to take, and these rapes have sexually violent predator specifications to them, are they really not going to base their decision about what happens to him about what he just pled guilty to?
From a defense perspective, all you can do is the best with the facts that you have. So what the defense has done is they're going to say, look, he's copped to these charges. He's not fighting them. He's pled guilty. He's taking responsibility, right? So that's going to be a factor they're going to try and use to mitigate his sentence. But, Jesse, I agree with you. From a jury perspective, I don't think even the defense attorney thinks there's a shot that there's going to be a not guilty verdict. The question is, what's that penalty going to be? And I will say there is a huge difference between hearing about some horrific crime like a rape and even seeing photos, forensics, and seeing a video of its actual occurrence. That, as much as the facts themselves are horrific, the video takes this to a whole other level that the defense attorneys knew. Think about the timing here, Jesse. That video was going to be at issue in the next couple of days. They knew they needed to take that issue off the table. He's dead to rights on it. There's a video of it. So confess, make it so it's not a question of fact that needs to be addressed with the jury, and suddenly that video is irrelevant and not coming into the courtroom.
So just one little note is that the judge will render a decision on any violent sexual predator specifications under the law after the jury verdict. So that won't be considered before, they'll be considered after. One little quick note, programming note, we are keeping a very careful eye right now on our other case, the William Riley Gaul case. There is a minor who is testifying right now, and under the court specifications, we are not allowed to show that testimony, but as soon as it starts up again, as soon as there's a new witness, we'll make sure to go into that case. We don't want you to miss anything from that courtroom. So again, that's the William Riley Gaul case. But let's focus back here on the Sean Great case. So in other words, is there any fight to say, look, this house that I was in, where I committed these crimes, there just happened to be the decomposed bodies of Stacey Hicks and Elizabeth Griffin. I never kidnapped them. I never killed them, but I did do things. I did do things
to their bodies.
Well, let's not. Well, that's not even true. I can't even say that because he did just plead guilty to the rape of Stacey Hicks. So again, how does one? Is there any way he could argue that he is not guilty of the murder and kidnapping of these women when he just pled guilty to raping one of them and doing inappropriate things to the corpse?
Right. There's an absolute uphill battle there because you've got the location of where the corpses are. You know, you have all these facts that are absolutely damaging to the defense. Jesse, I don't think he has a shot. I don't think you're going to hear the defense attorney get up there and say he didn't do it. And I'm not saying that, you know, with an alternative theory, it must have been somebody else. He just found the bodies there. I don't think you're going to hear that. What you're going to hear in their closing argument is something to the effect of the prosecution, based on forensic evidence, because these bodies were so decomposed, can't necessarily prove those murders beyond a reasonable doubt. And you're going to hear an attack on the forensics as opposed to an affirmative alternate theory of the crime, which we know isn't required from a defense perspective. Defendants don't have to say a darn thing. They can sit back and just let it all happen. I think that's what you're going to see here, because a jury's not going to like if this guy tries to say, oh, yeah, I just found the bodies there. I just happened to be wrong place, wrong time. That's not going to happen here. It's going to be an attack on those forensics.
Right. And we talked about it before that the attorneys in this case, they're going all or nothing. They didn't want to have a plea deal where he gets life in prison for the murders of these women. They want to seek the ultimate punishment for him.
I think based on what we just saw now, the fact that he pled guilty to all of these charges, which garner essentially a lifetime in prison, means that our theory was absolutely correct, Jesse. The prosecution is not willing to take the death penalty off the table. This guy's not afraid of serving life in prison. If the prosecution had said the death penalty is off the table, I think we would have heard a guilty plea to all of the crimes.
You might be right. Now, what we're talking about is this update in the Sean Great case. It happened this morning. It took us by storm. I want to play you right now. This was earlier today when Sean Great pled guilty to 15 counts in this 23-count indictment. Take a look. Welcome back, everybody. Okay, that was the big update this morning in the Sean Great case. That man, the defendant himself, pled guilty to 15 counts in that 23-count indictment. We've been talking a little bit more about it, and we'll talk about it a little bit later today when court resumes. But I do want to talk about a quick programming note. As you know, we are also covering the William Riley Gaul case out of Tennessee. Now, what's happening now is there is a witness on the stand who is a minor. She is Emma Walker's best friend, and we are not permitted to show her testimony. But as soon as the court starts up and there is a witness we are able to show, we'll make sure to go back into that courtroom. But I want to let our viewers know one other thing. As we talk about the Sean Great case, we're going back and forth today. I know we talked a lot about those charges that he did plead guilty to, what he didn't plead anything to. With the Sean Great case, our very own Aaron Keller is writing an article. It is coming up on lawandcrime.com. You can go there, read all about the case. You can have a better understanding of it, and we'll talk more about that Sean Great case in a minute. So again, we're switching back and forth today. I hope you're staying with me. Our focus right now will be back on the William Riley Gaul case. Okay, so the William Riley Gaul case, again, you have this young man, 18 years old at the time of this offense. He is on trial for stalking and killing his 16-year-old ex-girlfriend, Emma Walker, who was a cheerleader back in the day. This happened back in 2016, and it's alleged that Gaul fired 2 shots into her bedroom, and 1 shot hit her while she slept. She died instantaneously. Really sad case. What we're going to do for you right now is play some more of, we're going to play you more of the prosecution's opening statement. But before we do that, we have a short summary of this case that can help explain a little bit more about it. Take a look.
Trial of the man accused in the shooting death of a Knoxville, Tennessee teen is set to begin this week. William Riley Gaul, a former Maryville College football player, allegedly stalked and killed 16-year-old Emma Walker, a high school cheerleader, in November 2016. Investigators say Gaul and Walker were involved in an ongoing turbulent relationship and allege Gaul fired 2 shots through Walker's bedroom wall while she slept, killing the teen. Gaul was arrested in connection with the killing after he tried to recruit a friend to help him discard of the murder weapon, but that friend went to authorities, according to police. Gaul is charged with 7 counts, including first-degree murder and felony murder.
Okay, so that case is currently underway, but again, we're not allowed to have cameras in the courtroom right now because there is a minor who is testifying. But as soon as that changes, we'll make sure to go back into that courtroom. What I want to do for you right now is we're going to play for you some more of the prosecution's opening statement. But before we do, I know we don't have much more time with my guest today, unfortunately. I'm here with Misty Marris. This case, I want to talk about one of the charges. So he's charged with 7 different counts, including murder, stalking, theft of property. He pled guilty to reckless endangerment, which is firing a gun into a house. He took that guilty plea before trial. He faces anywhere from 3 to 15 years in prison and also a fine of up to $10,000. So we know he already pled guilty to that. But this other charge, which is a killing during aggravated child abuse, it is very similar to a felony murder rule, which is what we saw in the Tex MacGyver case. Explain to our viewers how that's kind of a loophole for the murder charge.
Well, absolutely, Jesse. That's what it is. So you have the murder charge, the first-degree murder charge. That's something he's facing. But the prosecution almost has a second crack at getting that lifetime sentence because the murder during an aggravated kidnapping means that you didn't necessarily have to intend to kill. It's similar to felony murder in that it's a murder during the commission of a felony. So the challenge for the prosecution is going to be proving the aggravated child abuse element. Then if the murder occurred within the commission of that crime, you'll have him on that charge. And again, a charge that carries a much higher sentence than some of the others.
Again, Aaron Keller wrote an article about this on Law and Crime. And as under Tennessee law, child abuse is treatment of a child. She was under 16. She was 16 years of age. She was under 18. And it's in a manner to inflict injury. And aggravated child abuse is serious bodily injury to the child or where a deadly weapon is used to accomplish that. So in other words, he's 18 years old. She's a minor. You don't think about it because he's not a parent. He's not a guardian, but he is older than her. And he used a method to hurt her. And that's the felony. It's such an interesting way of doing that because the same way we talked about the Tex MacGyver case where he was found guilty of aggravated assault, and during that aggravated assault, she died. There are critics out there who say this is unfair to defendants because the felony should be unrelated to an injury, right? So you see something like a robbery, somebody who goes into a bank, you don't necessarily think someone's going to get shot and killed right at that moment, but someone goes into a robbery, someone commits a bank robbery, and they fire a gun and someone dies, that's felony murder. So again, do you see the criticism there that this isn't fair to defendants, it's just another way for prosecutors to get a bite at the apple?
Yeah, I understand it. And the felony murder rule is highly criticized. There's a lot of critics of just the rule in general, which is the murder during the commission of an inherently dangerous felony. So like you were talking about, the example, it's the law school example. A burglary or a robbery gone wrong, somebody dies. The interesting part about this particular case is the actual act of him shooting that gun and killing her is the same basis for the aggravated the aggravated child abuse as for the murder. So it's not different.
Well, it's different in the fact that if it wasn't premeditated, right? So in other words, and by the way, you want to talk about a case of premeditation, the prosecution's really putting on a strong case. You have a guy who's alleged to be dressed in black, knew what he was doing, got the gun, went there. But even if the jury says, you know what, we don't buy that, we thought that he was a love-struck kid, he just wanted to come talk to her, maybe wanted to scare her, firing that weapon, which he just pled guilty to, firing that weapon into the house, that's the child abuse.
Yeah, but I think that actually the issue will be proving the aggravated child abuse. I do agree with you that for the purposes of the Tennessee statute, yes, the child abuse element absolutely could be fulfilled. But aggravated child abuse means that you're actually intending to cause injury. So how do you intend, here's the question, how do you intend to cause physical injury if you don't intend to actually hit her with that bullet? Right? And that's the dichotomy. And that's what's going on with the defense theory of the case. The defense actually is twofold. They're saying, yeah, he shot into the house, but he didn't mean to hit her. He only meant to scare her, which is more of a reckless, criminally negligent, something like that.
Well, those are the words that his own defense attorney was using a lot to stick in the minds of the jurors, that this was reckless, that he did a lot of stupid stuff, he was an 18-year-old kid. Will that work?
Yeah,
maybe.
Who knows? Well, they're going to say lesser, they're going to look for consider lesser included offenses in some of this and say it's reckless, it may be criminally negligent, but it's not premeditated murder and it's not aggravated child abuse. And I don't know.
Misty, it's pretty confusing.
It's really confusing. But I do think the one thing the defense has going for them is what we spoke about before, the fact that he did shoot from the outside in.
That is a key moment. It wasn't like he stood over her. It wasn't, he didn't
go in the house.
I'm not even entirely sure there was no way he saw her. I think he just he knew where the bedroom was. He'd been there. But the question is, I mean, I think that is a big key, and I'm sure the defense will exploit that fact nonetheless. So we're going to have to definitely watch that case. Misty, I'm so sorry you have to leave, but thank you so much for joining us this morning.
Thank you, Jesse.
Of course. Okay, everybody, we are going to go back now. We have the prosecution's opening statement from the William Riley Gaul case. We showed you some of it earlier today. I want to continue playing that for you right now. Take a look.